Hello, my name's Jim Biggart. I am the managing partner of Morgan & Morgan's offices in South Carolina, Charleston, Hilton Head, Myrtle Beach, and Columbia. Today we're going to be discussing pretrial demands, litigation demands, mediation presentations, and mediation strategies.
Personal injury cases hinge on the details. ABC Legal, America's most trusted process server, simplifies every aspect of service, so you can focus on winning your clients' cases. ABC Legal-empowered process servers deliver documents nationwide and make 12 million attempts annually, with real-time GPS-tracked updates and proof available online. ABC Legal's simple and transparent services make life easy for your team and help you keep costs under control. Your clients deserve consistent, reliable, and accountable service of process. Sign up for a free account today.
I got into law because I wanted to be a trial lawyer. I will maintain the respect due to the courts of justice and judicial officers. I started in the Navy out of law school. I was in the JAG Corps. I spent most of my time as a prosecutor and then ultimately went to an insurance defense firm in Florida, a statewide firm. I was initially in the Tampa office and then moved to Tallahassee, where I spent the next 15 or 20 years. I was on the defense side, and I worked with a lot of the very best Morgan & Morgan lawyers who were in the Jacksonville office. Unlike a lot of the firms that I had worked with in the past, Morgan & Morgan's lawyers were always the absolute best trial lawyers, extremely bright, good at what they did, and cared very much about their clients. There came a time when the Jacksonville office wanted to open an expansion office in Tallahassee. Greg Prysock called me and asked if I wanted to be involved, and of course I did. I took the chance. And here we are, 13 years later, and now I'm in South Carolina. I'm in the Charleston office with Morgan & Morgan. We have 12 attorneys, a staff of about 50 people. I run a team of trial lawyers throughout the state. Overall, we've got about 20 lawyers. There are basically two types of demands. There's a pre-suit demand and there's a litigation demand. They're both very important. Starting with pretrial demands. These are the demands that you put together before the lawsuit is filed. You're going to work up the case. You're going to figure out what the client needs in terms of their medical treatment. You're going to collect everything that there is in terms of medical records, bills, investigation materials, photographs. And so that initial demand that's going to go out to the insurance carrier is going to explain the case from the client's standpoint and also talk about the injuries, the treatment, the damages, the things that make the case. Litigation demands, on the other hand, are demands that we put out after the case is in suit, and they're meant to drive the case. Every time a plaintiff attorney sends a litigation demand, the defense lawyer on the other side has to present that to the insurance carrier. And so even though we have sent those demands out previously, each time we send a demand, it requires a response from the insurance carrier or the in-house counsel, and it requires them to take a fresh look at the case. And so pretrial demands happen before the lawsuit's filed. Litigation demands happened along with the lawsuit being filed and then later on as the case progresses towards trial. Preparation for a pretrial demand requires investigation. It requires a team. You have case managers who work with the clients. You have investigators that go and take photographs and video. Sometimes we have accident reconstruction investigations. It starts from the very beginning. Once the client comes to the firm, we get to know the client. We find out what's happened. We often send investigators out to the scene of where the incident occurred. We will get to know the client. We will make sure that they're getting the benefits they're entitled to. We'll make sure that they're getting the medical treatment that they need. One of the most important things to do is understand how the incident has impacted the client. And so we're going to learn about the client's everyday, day-to-day life. We're going to understand the treatment that they're requiring. We're going to make sure that before that pretrial demand is sent, that we have a clear understanding of not only what the injuries are and what the treatment has been, but also what treatment's required in the future. What does our client need in terms of long-term care? All of those things go into ultimately putting together a pretrial demand package. Now, once you get the pretrial demand package, you're looking at things like the medical bills, the medical records, photographs of the injuries, photographs of the incident scene, videos if you have them. Oftentimes there will be electronic downloads of the vehicles involved. And so all of those things are important to put together as part of the demand package so that the insurance carrier or the in-house counsel has a full picture of exactly what it is that you're trying to convey to them. We try to highlight the things that are most important for the client. If there are obvious weaknesses in the case, I might address those things, but I will do it in a way that doesn't detract from the overall point of the case, which is to understand why the client is having the problems that they're having and how the demand package explains all that. As you know, a photograph is worth 1,000 words. And so in our demand packages, a lot of times we will put pictures that show the scene of the incident. They'll show the client. They'll show the client maybe in the hospital, perhaps a photograph of the client's injuries. Whatever the case, we will include those photographs, links to videos if we have them, so that the person that's evaluating the case has the full picture, like we have when we're sitting down with our clients. When I write a demand, it's always going to be very straightforward, very simple, very straight to the point, concise. I don't use big words. I don't use lawyer-type language. I tell the story as if I were talking to somebody at my kitchen table. I explain what happened. I explain the impact on the person and how it's affected them personally, how it's affected their family, how it's affected their ability to do the job. And so tone is important, but it's also going to be very direct and straightforward. Mediation is an informal settlement conference. It's often required by the court before you can get a trial date. It's often agreed to before litigation happens. Most of the time, mediations involve both parties, a neutral attorney who's chosen by the attorneys to serve as the neutral, and it's a back and forth process. Our goals going into a mediation are to present the client's case in the best possible light. It is to present the case from a position of strength. We don't typically go into mediations explaining the weaknesses of the case. By the time we get to a mediation, we feel like we've got the facts and the law down and we understand the way that we're going to present the case. It is a collaborative process. The mediator wants to hear from both sides. Typically, the plaintiff attorney is asked to present their case first. When I do a mediation presentation, I'll often use videos, photographs, trial presentations, whether it's with PowerPoint or Keynote. I like to show it on the screen, and as I'm talking through what happened in the case, I'm showing photographs, I'm showing videos, I'm showing aerial photographs of the area where the crash occurred. This helps the people that are evaluating the case have a better understanding of where we're coming from and why we believe that certain facts are important. As I'm going through the facts of a case, I'm not going to be overly confrontational. I'm not going to be rude to the other side. I'm certainly not going to make anybody feel bad or embarrass the defendant driver in a case like that. I go straight forward. I am very straight and say, this is how we see the case. These are the facts of the case. This is what I think is important to the plaintiff. And I'll acknowledge the things that I think if I were on the defense side, these are the things that would be important to me. I will often set out those defense facts in a light that puts them in context so that everyone understands that although we acknowledge that there are facts that the defense is going to highlight, this is why they are either not important or this is why we believe that we're going to overcome them. Most of the time in a mediation, I'm talking directly to the insurance adjuster. The insurance adjuster is either in the room sitting across the table from me, but lately, the insurance adjuster has been showing up on video by Zoom. I try to make a personal connection with the adjuster. I try to acknowledge that we're grateful that they're taking the time to be here. I want to make sure that they understand that I know, having been a defense lawyer in the past, what's important from the defense's standpoint. I know that the defense lawyers worked up the case in a way that they're trying to impress the insurance company and the adjuster, and I try to acknowledge the hard work so that the defense lawyer gets credit for the good work that they've done on the case. By the time a case gets to mediation, we've typically put a lot of resources in the case. The insurance carrier has also put a lot of resources in the case. Most of the time, when we talk about going to trial, there are expenses involved. You have experts, you have trial costs, you have illustrations and demonstrative aids. All of those things can add up to a lot of money. Now, from our standpoint, it's what we do to give the client the very best presentation that we can possibly give them. From the insurance carrier standpoint and the defense lawyer standpoint, they do those things, whether it's surveillance or defense experts, things of that nature. They're doing those things to build the case from the defense standpoint. Now, one of the things that's less important from an insurance carrier standpoint, at least in my experience, is the cost of litigation. We've often talked about this is going to cost a lot of money if we go to trial. You don't want to have to spend all this money if we go to trial. The reality is the insurance company has those costs built in, and they're not going to settle a case for a lot of money simply because it's going to be expensive to try the case. If that were the case, as I've heard many insurance adjusters tell me in the past, there's going to be a run on the bank. And the plaintiff lawyers know that if they can get an extra $25,000, $50,000 because that's the cost of what it's going to be for the insurance company to try the case, they might throw that on top of the case. It usually doesn't work that way. Humanizing the case might be one of the most important things that you can do in your mediation presentation. One of the things that we try to embrace, we try to make most important, is simply a golden rule analysis of the case. How would I want this case presented if it were my family member, if it were my spouse, if it were my parent, if it were my child? How would I want this case to be presented by the attorney to give it the absolute most attention that it can possibly get? And the answer to that has always been put yourself in the client's shoes. We all know that you can't do that in trial. It's called the golden rule and it's inadmissible. But in mediation, it's fair game. And I'll ask the insurance adjuster, put yourself in my client's shoes. You've got X amount of money that's available under the insurance policy. If you were in my client's situation, would $500,000 compensate you for what my client's been through? If you had to switch places with my client, if you had to go through the trauma and the pain and the treatment, and if you had to be stuck with everything that my client's going to be stuck with for the rest of his life in terms of the human damages and the pain and the suffering, would you be willing to do that? And if the answer is absolutely not, I'd never do that for that amount of money, well, then what are we doing here? Because the answer is you should have already given my client the opportunity to settle this case with your policy limits. And the fact that we're here means that you're being unreasonable in the way that you're evaluating the case. We try to make sure that we are looking at our case from our client's standpoint. And that means put yourself in your client's shoes. How do they get up in the morning? What do they do on their way to work? Once they get to work, do they need help? Are there things that need to be done for them? How can we explain this case in a way that the insurance carrier, the defense lawyer, and ultimately a jury, potentially, is going to understand the case? I spent almost 18 years on the defense side. I know what it takes to work up a case from a defense lawyer's point of view. I know what's important to the carriers. And so I brought that information, that experience with me when I joined Morgan & Morgan and began working for my clients. One of the things that's most important to understand about insurance companies is that they are going to try to get the case resolved at the earliest possible time for the least amount of money. Insurance companies are not about doing the right thing. They're not about making things right. They're not about being fair. And so at the beginning of the case, the insurance company is going to make a low offer. Let's take, for example, a standard car crash case. A defendant driver runs into the back of a plaintiff's car. Say the plaintiff suffers a broken leg. The plaintiff goes to the emergency room, is treated, has follow-up care, goes through physical therapy, has to go to an orthopedic surgeon. Ultimately, has to have a surgery to repair that leg. Now, the facts of the case are known. Within the first month of what happened in that case, it's known. The insurance company knows who's at fault for the accident. They know what the injuries are. They know what the damages are. They know likely what the future treatment's going to look like. But the insurance company is going to make an offer that looks like this at the beginning of the case, hoping that the lawyer or the client is somebody that's going to take the first offer and go away. We know that if we stay in the case, if we move the case towards litigation, if we file suit, we know that the insurance company, even though the facts haven't changed, they're going to add money to the offer. After the lawsuit's filed, you'll get a call from the defense lawyer. Hey, I've just been retained by the insurance company. Can we talk about settling the case? Even though nothing has changed about the case in terms of the damages, now the insurance company's put more money on the case. Fast forward 3 or 4 months. You might be at the plaintiff's deposition. After the plaintiff's deposition, the insurance company has heard the same story they knew before. The injuries, the damages, the future treatment. They're going to put more money on the case. Fast forward to 6 to 8 months. You might be in a mediation conference. Nothing has changed about the facts of the case. It's still a clear liability case. It's still a broken leg with a surgery. It's still all the treatment that the client needs in the future. But the insurance company has gone from this much in the offer they're making to this much at the time of the deposition to this much at the time of the mediation. Nothing has changed about the facts of the case or the law in the case. If you keep moving through mediations towards trial, you see that the insurance company continues to add more and more and more money on the case. It's not that the facts of the case have changed. It's because the insurance company knows that if they can settle that case for the least amount of money at the earliest possible opportunity, that's going to be best for the insurance company. Good trial lawyers know that if you stay with the case, if you build it out, if you go through the mediation and you're prepared, if you go past mediation towards trial, that's when the best offers are going to come. That's when you can get closest to real value on your client's case. A lot of times you'll have the opportunity to talk to the defense attorney before the mediation starts. You may have experience with that lawyer from the past. You may have a good working relationship with that lawyer. You call the lawyer up, you have a conversation about what's likely, what's possible. What is the insurance company likely to do? Does the defense lawyer have a relationship with the insurance company's adjuster so they might be able to give you some insight? It's important to work with the lawyers on the other side so that there's an understanding that when we come into the mediation, here's what our expectation is going to be. It's highly likely that we've already sent a demand package. It's highly likely that we've already made a demand for the policy limits or even beyond the policy limits. Setting expectations with the defense lawyer is important because we don't want to surprise the insurance company when we get to the mediation. By the time a case goes to mediation, the defense lawyer's met with the insurance carrier. The insurance adjuster has met with their supervisors. They've already decided what's the range of settlement that they're willing to take. And so they come into the mediation with an expectation, with a range of what they're willing to pay to settle the case. If, as the plaintiff lawyer, you come in with new information, with new damages they haven't seen before, it may be compelling, but the insurance adjuster and the company is not going to be able to settle the case at that point because they don't have the reserve set in place. It's important to have those conversations with the defense lawyer so you set expectations before going into the mediation. Most of the time, in my experience, pre-demand discussions with the defense attorney don't really move the needle on the case. We go into mediations expecting them to pay fair value. The insurance companies go into the mediations hoping to steal the case. That's not the way that we do business. Full value to us means we go into the mediation, and if the case is worth the policy limits, that's where we're going. If the case is not worth the policy limits, we're going to settle the case at something that's fair, but not something that's unfair. One of the things that the plaintiffs have to prove is the amount of future medical expenses. It's our burden of proof. We need to show what the plaintiff is going to need in the future in terms of medical care, whether that's doctor's appointments, diagnostic studies, procedures, physical therapy. It's important to know what those future expenses are going to look like. Oftentimes, we will have hired a doctor who will put together a life care plan. It's a projection of what the future medical expenses look like. It quantifies what we'll be presenting at trial in terms of the future medical expenses, procedures, and treatments that the client's going to need. Ideally, you've shared that with the defense attorney and the insurance company before the mediation starts. If you go into mediation with a life care plan that's several $100,000 and the insurance company hasn't seen that before, or the defense lawyer is surprised by it, it's important information from the plaintiff's standpoint, but it's going to put you in a position where the insurance company hasn't looked at it, hasn't considered it before, and it's probably going to derail the mediation at that point. Past results, whether it's in trial or at prior mediations or settlements, is important because it gives you a benchmark of what to expect in a case like yours. And so in Morgan & Morgan, we have an annual verdict magazine that comes out, and it talks about the very specific cases that we've had and how much we've been able to settle cases for. It's also important sometimes to do your research. Jury verdict research is important according to the jurisdiction that you're in. A lot of times you can find cases that are very, very much like your case that's going into mediation, and you can show the defense attorney and the insurance carrier what these kinds of cases have brought in terms of verdicts in the past. It's especially important in specific jurisdictions. If you have counties in a state that are unlike bigger counties in the state, you may have very different verdicts. You may have very different settlements. And so defense lawyers know, and oftentimes insurance carriers know, that different counties can have a profound impact on the value of a case. In the right kind of case, accident reconstruction experts have a huge impact at mediation. Sometimes I will go to the accident reconstruction expert and we'll record a video that has the expert showing the reconstruction of the accident, whether it's by animation or some other means. That's a very, very compelling way to explain how the accident happened and why the defendant is responsible. The accident reconstruction expert goes into a case trying to understand and recreate and explain what happened in the accident in a way that helps your client. If you can show how the accident happened from your expert standpoint, it is invaluable. In cases like ours, most of the time, the most important question is, how has this affected you? What's different now? What did you used to enjoy doing that you can't do anymore? When we look at the case and we're preparing for mediation, we talk to our clients about what's the most important thing. If you could explain how this has had an impact on you, what would you tell somebody about? Sometimes, in the right kinds of cases, we will ask for a day-in-the-life video. A day-in-the-life video is a production where we film our client doing what they do throughout the normal course of a day. We show that it's difficult for them to do the things that they used to be able to do. The video shows the impact that the injuries and the treatment have had on our client, and it provides a more humanistic approach to the way that our client has been impacted by the injuries that he or she has suffered. Mediation presentations are extremely important in my view. I'm a big fan of using trial presentation software, things like PowerPoint or Keynote, to put together a professional presentation and use that as a way to make compelling arguments, compelling points about the things that are important in the case. Oftentimes I will use the presentations as a way to go through what would otherwise be an opening statement. Some people may have an outline and go from a visual cue on what they want to talk about. I use the presentation software and the photographs and the videos of things in my case as talking points, things that I want the other side to hear about my case that I think is important, that's highlighted by the photographs and the videos. It's important to have accurate data when you give your mediation presentation. You need to be sure that the amount of medical bills you have is correct. You need to be sure that the future medical expenses are accurate. You want to put those together in a way that's easily understandable and digestible by the defense attorney and the insurance carrier. The most important data is the economic damages that you're going to be presenting. There's past economic damages in the ways of medical expenses, in the ways of lost wages in the past. There's future economic damages in the way of future medical expenses, future needs, future care. It's important to have all of that data in place going into the mediation and it be accurate so that the best presentation is possible for the defense and the insurance carrier. Sometimes it's important to have timelines in a mediation presentation. The defense often will pick on plaintiffs for having what's called gaps in treatment. Gaps in treatment are time periods where there's been treatment with one doctor or provider and then a period of weeks or months that go by before the next treatment occurs. Those gaps in treatment often don't hurt the case at all, but insurance companies love to talk about gaps in treatment. And so a timeline, either showing the treatment on a linear scale or by showing a calendar with all the treatments, can highlight the way that your client has treated over the last 6 months, over the last year. And so if you can show that in a visual way, it becomes evident that your client has been treating all along and these gaps in treatment really aren't gaps at all. After the opening statements in a mediation, the mediator typically will separate the defense and the plaintiff into different rooms. At that point, the mediator goes back and forth and talks with each side, often plays devil's advocate, tries to get to know the plaintiff, tries to get to know the defense, to get a better sense of what's going to happen during this mediation. It's important from my standpoint to start the negotiation in the right place. The initial demand is critical. It sets the tone for the rest of the mediation. Oftentimes, you'll go into a mediation knowing that you're not going to accept less than policy limits. Sometimes you'll go into a mediation knowing that you can settle the case under the policy limits, but it's going to be under your terms. Depending on the nature of the case, especially a case that's worth significant damages, we'll often run focus groups or even mock trials to get a better understanding of what jurors think of the case, what's important to the jurors, what's not important to the jurors. And sometimes the results are absolutely amazing. And so if you have a case with high damages, where you're going to be asking for significant recovery. It's important to understand what's the best approach. And how do we get there? Well, we do focus groups. We ask other people that are likely going to be sitting on juries in our cases what they think of the case, what's important to them, what's not important to them. We try to understand the things that are most important to the mock jurors so that we can get a better understanding of what the value of the case might be. If I have good focus group data, I will often reference it in the mediation presentation. I'll share it with the defense and with the insurance carrier, and I will say, we have put this information in front of 100 strangers. The same types of people that are going to be viewing this case as jurors if the case goes to trial. Here's what they say. This is the range of the amount of money that they were willing to award in this case. It's important because a lot of times these insurance company adjusters are from different parts of the country. The people that are making the decisions on how much they're willing to pay to settle this case don't understand what it's like to be in Jasper County, South Carolina. They don't know what it's like to be in Georgetown, South Carolina. And so it's important to try to use focus groups or other local data points to explain why your case has value that they may not understand in your particular venue. There's been a lot of research in the last 20 years about anchoring. Anchoring is when you set an amount at a very, very high level. And the expectation is that if I anchor super high, say $5 million, the jury may not agree with me that the case is worth $5 million, but what if they give you $3 million? That's the idea behind anchoring. In a mediation context, it's important not to put that number so high that the defense and the insurance carrier loses interest or thinks that the case can never be resolved. You want to put your number at a point where you can negotiate it from, but at the same time, you're not making the insurance company run away thinking there's no chance you're ever going to settle the case. Oftentimes, the judge will make you go to mediation before you can get a trial date. Anytime I go into a mediation, I want to start with a position of strength. I want the other side to know that we're ready to try the case, and we are. From the very beginning of the case, we will start to prepare for trial. Mediation is just one of the steps along the way. I know that if the case doesn't settle at mediation, the next thing that comes in line is going to be getting ready for trial. And I make sure that the defense lawyer and the insurance carrier knows that we're ready for trial. It shows by the presentation that we put together at mediation. It shows by the way that we conduct our depositions. It shows by the way that we put together our presentations. The defense attorneys know the lawyers that will try a case and the lawyers that won't. If you go into a mediation from a position of strength and the defense lawyer and the insurance company knows that you're the kind of lawyer that will try that case, you're going to be in a much better, stronger position than you would otherwise be in. After a mediation, if the case doesn't settle, most of the time I'll send a follow-up demand to the insurance company and the defense lawyer. I will highlight the things that I presented during the mediation process. I will provide another copy of all of the medical records, the bills, the important documents, the photographs, the videos. I'll give them another chance to settle the case for what we determine to be fair value. It's important to have those follow-up conversations with the defense attorney because oftentimes there is a solution that gets you from the impasse at mediation to a resolution and an ultimate settlement. Maintaining those communications with the defense lawyer is often critical in getting the case resolved in the next week or two after a mediation is at impasse. I go into a mediation knowing that the case is unlikely to settle, knowing that the insurance company is not going to bring the kind of money that it takes to settle this case. Oftentimes, the insurance company will offer you a little bit of money to see if you're willing to take it. You have to be willing to turn it down. It's not a whole lot different than going to buy a car and being willing to walk out of the dealership if they're not giving you the kind of price that you want. It's the same process. The insurance company is trying to get you to take less than the case is worth. The mediator is trying to get you to take less than the case is worth. You're doing everything you can to try to get the most you can for your client, mainly what's fair in light of all the injuries and the damages that your client has suffered. And so when I go into a mediation, I know it's unlikely the case is going to settle at mediation. I'm still going to give it my absolute very best. I'm going to put on the best presentation I can because it sets the stage for the next mediation or the third mediation, or it even sets the stage for the case to go to trial. Several years ago, I had a client who was involved in a terrible crash. As she was driving her two kids to school, a gentleman pulling a trailer from the opposite direction lost control, came across a highway and hit her nearly head on. It was a horrific crash and she was severely injured. She spent the next several weeks in the hospital, only to be transferred to a rehab hospital after that. She had life-altering injuries. the kind of injuries that nobody would ever want to have to deal with. The complicating thing about this case was that there were two defendants. One was the driver who was pulling the trailer. The other was the company that provided the trailer on a rental. The defendant that provided the trailer denied any responsibility whatsoever. And so it was important that we establish at the beginning of the case that the crash happened because of the equipment that was rented was faulty. It was dangerous, and they put a ticking time bomb on the road. From the very beginning of that case, we started out by using photographs and videos. We got an accident reconstruction expert involved. We did everything that we could do to collect every piece of information that would show what happened in that crash. By the time we got to mediation, we had done dozens of depositions. My client had been deposed. She had been able to explain what happened, but really what she was able to share wasn't that important in terms of what happened in the crash because she was just trying to get out of the way. The real important information about the crash was how the person lost control of the trailer, why the trailer jackknifed, and why he came across the highway and struck my client. Before we got to mediation, I put together a comprehensive demand package. The demand package included not only the medical bills and the medical records and the operative reports and the photographs and the videos. It also included what's called a day in the life video, where I had somebody go and follow my client around, doing the things that she did every day. Happens that my client was a nurse and she worked at one of the university hospitals. The injuries that she had suffered made her job so much more difficult than she'd ever experienced before. She'd gone from being a person who was on her feet all the time, helping other patients, to somebody that had to take breaks, to somebody that had to sit down, somebody that wasn't able to do the job, couldn't manage the physical requirements of the job anymore because of the injuries that she had. And so it was important before we got to mediation for me to be able to show exactly how she was living her life, how she would go to work, how she would take care of her children. That day in the life video, part of the presentation, it was critical in showing the human quality, the things that she dealt with the most, the things that were lost through no fault of her own, unnaturally by somebody who wasn't doing what they were supposed to be doing. By the time we got to mediation, the insurance company and the defense lawyer had a clear understanding of what was important to our case. They had videos, they had photographs, they had an accident reconstruction expert's testimony about how this accident happened. They knew exactly how we were going to try this case, and they knew that if they didn't settle the case, that they were going to face an uphill battle in convincing a jury that this wasn't their fault. One of the most important things about this case was knowing that the first mediation might not be the time that this case settles. Oftentimes, when you're dealing with significant damages in the millions of dollars, insurance companies aren't going to come to the table with that kind of money on the first mediation. You have to set the stage. And so you go into the mediation with an understanding that this is going to be the first step, that there's going to be more steps in the future, and that even if you don't get this case settled at mediation at the first time or the second time, each time you go through this process, you're explaining to the defense and the insurance carrier what they can expect to see at trial. And you're making it more and more likely that they're going to offer fair value to settle that case, far beyond what they would have done otherwise. That was a difficult case. We actually mediated the case 3 times. The first 2 times obviously weren't successful. The third time was literally the week before trial. As I said before, we know that the insurance companies aren't out there to do the right thing or to make the fairest offer. They're going to dangle money in front of the lawyer, and they're going to dangle money in front of the client to see if they'd be willing to take less than the case is worth, to see if the lawyer was the kind of person that would be willing to take less than what their client deserves. By going through those mediations, the first one, the second one, and then the third and final mediation the week before the trial happened, we demonstrated that not only are we ready to go to trial, we demonstrated that we are willing to go to trial. We demonstrated that we're willing to do everything that it takes to get the trial the very best outcome. By the time we did that third mediation, the week before trial, the insurance company came with the kind of money that we thought was fair, the kind of money that would actually address the human injuries and the damages that our client had suffered. And it was a resolution in that case that would enable the client to go on for the rest of her life with the kind of resources that she needed in light of the injuries that she had. Morgan & Morgan is the largest injury firm in the world. We have the resources to go up against the very largest insurance carriers. When you're dealing with a multi-billion-dollar international insurance company, they can throw their weight around. Well, if you're at Morgan & Morgan and you have the resources that we have, we can stand toe-to-toe with those carriers any day, any time. And we do. We make it clear that there's no amount of money that we're not willing to spend on behalf of our client if it's the right thing to do. One of the most important things to Morgan & Morgan is going into that mediation from a position of strength, demonstrating that we're ready to try the case. There are lots of plaintiff attorneys out there. They all advertise big results. Morgan & Morgan decided to change the way that we do business with insurance companies. We decided that we were going to try our very best cases. We were not going to settle for less. We were not going to go into cases and take less than what was full value on the case. And if that meant trying the case, that meant trying the case. Because we know that the best value, the best result for our clients is going to happen when we get to trial, or shortly before trial, or even sometimes right after trial has happened. We know that the insurance company's top dollar is going to come when we are at the doorsteps of the courthouse, when we're ready to try the case. And so we don't go into the case thinking, how can we settle the case? We're looking beyond that. If the insurance company is willing to pay fair value on the case, we'll settle that case at mediation. But if they're not, that case is going to trial, and we're going to get fair value for our clients every time.